I guess our request is either A, that the state be required to plead with more specificity what it is that they think is reckless, or alternatively, the reckless portion be struck from the indictment.
This is cause number 24 DCCR 00.
Today's courtroom showdown is one you don't want to miss. Defense attorneys are going head-to-head with the state over a critical detail: recklessness. Was the indictment too vague, or did the prosecution do just enough to keep the charge alive? At the center of it all is Austin Jones, appearing via Zoom, facing aggravated assault charges. The defense is fighting to cut out the word reckless from the indictment, a move that could seriously change how this case plays out at trial. But will the judge side with them, or stick with the prosecution's broad interpretation of the law? Stay tuned, because the ruling here sets the tone for everything that follows in next week's trial.
To ask, it appears it says you're asking the court to excise the defective portions. If you'll explain what you're specifically asking for and what you think is inappropriate.
Sure, Judge. So as you know, aggravated assault of this nature, where it pleads serious bodily injury, allows the prosecution to plead intentional conduct, knowing conduct, and then reckless conduct. In this instance, the problem is the reckless portion of the indictment is not matched with appropriate language specifying the nature of the recklessness as required under the statute, under Article 21.15. And so I guess our request is either A, that the state be required to plead with more specificity what it is that they think is reckless, or alternatively, the reckless portion be struck from the indictment going forward, such that they can only proceed on intentional and knowing conduct.
Mr. Hoffpower?
Your Honor, we're tracking the statute. This is how we file all aggravated assaults. They all have, those are in the statute, the three.
Can y'all hear Mr. Hoffpower?
Am I speaking loud enough?
There's the.
I can hear him fine, Judge.
Okay.
Knowingly, I mean, this is part.
I can hear him fine.
The statute of aggravated assault, it always has knowingly, intentionally, knowingly, or recklessly. I'm not sure why, in this particular case, we need to excise that. I mean, that's always how we file that, and it's tracking the statute.
So from my reading of the indictment, and we're all obviously making assumptions, isn't something that we should do, but I would think that the reckless, to me, it would read, that any of those, intentional, knowing, or recklessly, that the action of those is the shaking with the defendant's hands. So how is that not specific enough? I guess my question, Mr. Gertz. Oh, I can't hear you. You muted yourself.
Sorry, I apologize. The answer is, Judge, this case that I cited in my my motion, State versus Rodriguez, requires the state to provide the acts and circumstances surrounding the allegations that the state intends to prove were reckless. And it goes on to give an example of saying recklessly discharging a firearm by pulling that an ordinary person would normally apply here, that he has knowledge of. And that's just not contained in the pleading.
I'll respond quickly, Judge.
Yeah.
And I'm not sure about this particular case, but I have had one of these before in regards to reckless deadly conduct, where you understand, like, there's a felony and a misdemeanor, and recklessness is a part of that particular charge, which makes it whether or not, whether it's a felony or whether it's a misdemeanor. But to my knowledge, there's not analogous to what we're talking about in our case, which is an aggravated assault with a deadly weapon, in which we do give I think we pled the case sufficiently.
I think if it had, so I'm looking at Article 2115, which obviously says that it must specifically have to do with this one, recklessness and criminal negligence. that the act or acts relied upon to constitute recklessness must be alleged. I'm going to deny the motion to quash. I believe the indictment alleges sufficiently the acts of shaking with defendant's hands as the potential or alleged reckless or intentional or knowing. But I think there's enough specificity for the defense to know what is alleged that his client either did or omitted from doing with regard to the recklessness. So I am going to deny that motion. Is there anything else that you guys know of that we need to kind of be prepared for before jury selection on Monday with regard to any other pretrial issues?
No, Judge, as far as I'm concerned, that was my only issue.
Okay, so we will, if anything comes up, just y'all know how to get in touch with me. Let me know. We can take care of it either. If it has to be taken care of before board hour, we'll do it. If not, we'll do it that afternoon after we go through jury selection. All right, so we'll see y'all back here.
And Judge, just so you know,
Go ahead.
Judge, just so you know, I may raise this issue again as the trial progresses. I just needed to preserve it 10 days in advance under the statute. And so I understand the court's ruling, but depending on what the evidence is, et cetera, I may raise it again.
Okay.
Because I anticipate what's going to happen, Judge, is that the experts for the state are going to try to allege intentional conduct. And again, part of the problem part of the problem with this statute is it allows them to do all three. And so I'm just letting the court know that I'm going to be likely raising it again, depending on what the evidence is. So.
Okay. We'll take that up at the appropriate time if it happens. Mr. Gertz,
I appreciate it. Thank you, Judge.
Would you have your office send an order over for me to, for that motion to quash? They did. Never mind. They already did.
I'm sorry. That's not.
Okay.
All right. Thank you both. You're excused, Mr. Jones and Mr. Gertz. See you next week.
Thank you, Judge. We'll see you Monday. Thank you.
What a dramatic exchange we just witnessed. Let's break it down. At the heart of this motion was one key issue: recklessness. Under Texas law, aggravated assault can be charged three ways: intentionally, knowingly, or recklessly. But the defense argued that the indictment was flawed because it didn't clearly explain what specific acts were considered reckless. Without those details, they claimed, the charge was too vague, making it harder for the defense to prepare a fair case. Now, why is this so important? In criminal law, words matter. The difference between intentional, knowing, and reckless can decide the outcome of a trial. If the jury is allowed to consider recklessness without clear boundaries, it opens the door for broader interpretations that could heavily favor the prosecution. The defense lawyer even cited precedent, State v. Rodriguez, where the court made clear that prosecutors must outline the specific acts that show recklessness, not just broad conclusions. The prosecution pushed back, arguing that they followed the statute exactly as written. Their position was straightforward. Every aggravated assault indictment includes all three mental states, and this one is no different. They insisted that the act, shaking with the defendant's hands, was specific enough to cover reckless, intentional, and knowing conduct. And here's the kicker. The judge agreed with the state. By denying the motion to quash, the judge effectively ruled that the indictment gives the defense sufficient notice of the allegations. That means all three mental states, intentional, knowing, and reckless, will remain on the table when the jury trial begins. Let's pause and think about the implications. The defense wanted to limit the jury's options, narrowing the case to intentional and knowing conduct only. Why? Because proving intent is often harder for the state. T requires showing the defendant's state of mind beyond a reasonable doubt. Recklessness, on the other hand, gives the prosecution more flexibility. It allows them to argue that even if the defendant didn't mean to cause harm, his actions deviated so far from normal standards of care that he should still be held criminally responsible. In short, keeping recklessness alive makes conviction more likely. Another important takeaway is the defense's strategy here. By raising this motion now, they preserve the issue for appeal. Even though they lost today, they can raise the same objection during trial. And if the jury convicts based on recklessness, they'll have grounds to challenge the ruling later in a higher court. That's a classic example of how legal battles aren't always about winning in the moment. Sometimes it's about setting up a safety net for the future,